Most nurses think that legal nurse consultants just write chronologies, but I'm about to show you 7 different work products that can each generate thousands or even tens of thousands of dollars per case. If you enjoyed this video, be sure to like it and subscribe to my channel. I'm Randy Lovelace, and I've been creating legal nurse consulting work products for years across multiple businesses. One of the biggest misconceptions that new legal nurse consultants have is thinking that their job is just to summarize medical records. And the truth is, attorneys need a wide variety of products depending on where they are in their case development, and your ability to provide multiple types of analysis is really what exponentially makes you more valuable to their practice. So today I'm going to walk you through the 7 most common work products legal nurse consultants create, what each one entails, and when attorneys typically need them. Now, before we dive into specific work products, let me explain why this matters for your business. When you only provide one type of service, you're limiting yourself on how you can serve attorneys. But when you can offer multiple work products, you really become a versatile resource that they can turn to throughout the entire life cycle of a case. Andrea, she's one of our Catalyst clients, and she went from being laid off in her executive role in a hospital to becoming the chief operating officer of my legal nurse consulting firm, partly because she mastered each of these work products. She can handle everything from initial case screenings to complex trial prep, and that really makes her invaluable to both attorney clients and me. So, diving in, work product number 1, comprehensive chronologies and reports. Now, this is what most people think of when they hear legal nurse consultant, and it's often the foundation of a lot of the cases we do. A comprehensive chronology is a detailed, organized timeline of all the relevant events within a case and our analysis of their significance. This typically includes things like chronological listing of all the medical events, relevant notes from the medical records, identification of any key issues or red flags, analysis of the standards of care and deviations therein, potential causation issues, areas needing expert witness consultation, and a number of other things. And we teach you all of this in Catalyst, but when an attorney needs this sort of thing, it's typically going to be earlier in case development because they're looking to understand the full medical picture, or it could be preparation for depositions of different medical providers. It could be during times of settlement negotiations that are requiring comprehensive medical understanding, or trial preparation when all the medical facts need to really be organized. And then finally, they use it when they're looking for expert witnesses, looking to recruit and prepare expert witnesses. And what makes this so valuable, a well-crafted chronology and report really does more than just organize dates. Anybody can do that. What it does is it tells the story of what happened medically and why it matters legally. You're connecting medical dots that attorneys really can't connect themselves. Key components of a comprehensive chronon report are things like clear timeline format that's easy to navigate, making sure you have accurate medical terminology with lay explanations when needed so that the attorney can understand what's being said, identification of missing records or documentation gaps, highlighting critical events and their significance, analysis of whether care met accepted standards or deviated, and recommendations for further investigation or expert consultation. The second work product, brief summaries of causation. This is more focused on work products that address specific causation questions. A brief summary of causation analyzes whether medical actions or inactions directly caused or contributed to the client's injury or adverse outcome in medical malpractice cases, and clearly identify causation in a simple report in PI cases. Attorneys need this when the initial case screening is happening so that they can better understand if causation even exists, and before investing tons of money into expert witnesses or other expensive endeavors. For insurance companies, evaluating claims, they might need a brief summary of causation. Settlement discussions that focus on liability could be supported by a brief summary of causation, or preparation for mediation. The key elements in a brief summary of causation include things like a clear statement of the medical issue or the injury sustained, a brief story of the relevant medical events, analysis of how care may be deviated from standards of care if you're working on a med-mal case, and then, of course, explanation of how those deviations led to injury or damages, and discussion of any intervening or contributing factors, and then finally a conclusion about the strengths of the causation arguments. And this sort of report has a lot of value to attorneys. Attorneys need to know early on whether they have a viable case, and a well-written causation summary can save them from pursuing cases that might be weak, have weak causation, or can help them recognize strong cases that they might have otherwise missed. All right, number 3, and we're working backward here a little bit. Work product number 3 is a merit review. This is more simple than the brief causation. Merit reviews are arguably one of the most important work products that attorneys need in the early stages of case evaluation. A merit review is a preliminary evaluation of whether a case has any sort of legal merit, or from a medical standpoint at least. And it's typically going to be a shorter analysis. Think a couple paragraphs to maybe 1 or at the max maybe 3 pages. And this is going to help attorneys decide whether to invest further resources into a case. Attorneys need this when initial case screening is happening before accepting representation on a case, before spending money on voluminous medical records and experts. Well, they need it when deciding whether to file a lawsuit in the first place, and sometimes they need it for insurance companies evaluating potential exposures. And if an attorney is unsure if they should pursue a case or not, getting a merit review from us can really help them decide. Key questions that are addressed in a merit review: was there a deviation from standard of care if it's a med-mal case? Was there apparent causation between the event and the injury in a PI case? Are the damages significant enough to even warrant litigation? There might be a case there, but is it going to bring in enough that would even cover your expenses and add a little profit to your pocket? What are the strengths and the weaknesses of the case? What additional records or information might be needed if you are going to pursue it? And finally, ultimately, should the attorney actually pursue the case? And components of a strong merit review include things like a brief overview of the medical situation, identification of potential standard of care issues and med-mal cases, preliminary causation analysis. Again, this is high level, but you're still giving an analysis of causation in PI cases or deviation from standard of care in med-mal cases, assessment of damages and their severity, and then discussion of the case strengths and the potential weaknesses or challenges. Ultimately, you want to give a clear recommendation. Should they pursue it? Should they investigate further? Or should they decline the case? And the business reality of this is that merit reviews are incredibly valuable because they help attorneys avoid expensive mistakes. Attorneys might decline 5 or 10 cases after a merit review for every one that they pursue. But that means that we're saving them from wasting their resources on cases that simply aren't winnable. Work product number 4, demand letters. This is a specialized work product that can be extremely lucrative for legal nurse consultants. A demand letter is a brief yet comprehensive document, and typically it's sent to insurance companies or opposing counsel. It outlines medical facts of the case, injuries and damages suffered, impact of the injuries that were suffered to the client, and the basis for compensation that's being demanded. And when attorneys need it, is typically in pre-litigation, when they're in settlement negotiations. They may not have filed the claim yet. Insurance claim submissions. They may need it as a foundation for mediation discussions. When attempting early resolution without trial, also a great time to have a demand letter. And why it's valuable is that a well-crafted demand letter, supported by a strong medical analysis, can result in significant settlements without the expense of tons of time or going through litigation. Some of our Catalyst clients specialize in demand letters. One recently told me about a case where her demand letter helped an attorney achieve policy limits, the maximum insurance payout available. And that attorney immediately gave her 2 more cases. And the best demand letters are factual and objective, not emotional or accusatory. They're supported by strong medical evidence. They're clear about causation and damages. They're presented professionally, and they're compelling enough to motivate settlement. All right, work product number 5, IME or DME observations and reports. Independent medical examinations, or IME, and defense medical examinations, DME, basically same thing, just a different name. There's some other names too that I won't get into here. They present unique opportunities for us as legal nurse consultants. Attorneys often need a medical professional to observe these examinations and document what actually occurred, as opposed to what appears in the examining physician's report. And there are 2 types of work products here. The first one is observation services. So you're attending the examination in person, you're taking detailed notes of what occurred, you're documenting questions that were asked and what wasn't asked that maybe should have been. You're recording the examination and the techniques that were used. You're noting the duration and the thoroughness of the exam being done. And you're observing the patient-examiner relationship. You're really looking for interactions between those two. And then the second thing is you're writing a report, written analysis of the examination, comparison of what occurred versus what was reported by the physician, identification of omissions or inaccuracies in what they might be saying, analysis of whether the examination was actually adequate, discussion of bias or leading questions that really shouldn't be asked, and recommendations for cross-examination. Now, depending on the state legislation and agreements between the attorney and the examining provider, audio or video recording might also be requested. And when attorneys need this to be done is when they suspect biased or inadequate examinations, or for high-value cases where the stakes are quite significant, or when preparing to depose the examining physician, and for cases where medical opinion is probably going to be contested, and when they need documentation beyond the examiner's report to support what was actually happening in the IME or DME. These observations can be super crucial. They can be critical for impeaching biased medical examiners, which happens, demonstrating inadequate examinations that were done or not done, critical for supporting motions to exclude or limit testimony, and very pivotal in preparing effective cross-examination or establishing bias in opposing medical opinions. Okay, last, work product number 7. This I'm going to just call additional specialized products. So beyond the major work products I've already discussed, there are several specialized services that legal nurse consultants can provide. Things like literature research, finding medical studies, supporting case theories, researching standards of care guidelines, or locating evidence-based protocols. I've done timeline graphics and visual aids. So creating visual representations of medical events or developing demonstrative exhibits for trial, designing educational materials for juries. Another place we might be asked to help out is in medical record organization. So organizing, indexing large record sets, creating searchable databases, identifying missing records. Let me think. Expert witness vetting is another spot. Researching potential expert witnesses, reviewing the expert witnesses' credentials and publications, kind of vetting them, checking their testimony history. Sometimes we help with deposition preparation, preparing the attorneys for deposition of medical providers and suggesting questions, follow-up questions, cross-examination questions, explaining medical concepts and terminology to them. And the more work products that you can competently provide, the more valuable you become to an attorney. Instead of being the chronology person, you become their comprehensive medical resource throughout case development. And mastering these various work products requires 3 things. It requires technical skill development, such as understanding what attorneys need at each stage of their case development, learning to analyze medical issues from the legal perspectives, developing clear, compelling written skills or writing skills, building research, investigation capabilities, and it requires strategic thinking, understanding the case development from intake to trial, recognizing what information matters most to the attorney and to the case, and anticipating what opposing arguments might be, and start thinking like an attorney. And number three thing it requires is business acumen, pricing your different work products appropriately, managing multiple project types simultaneously and getting them on into the attorney on time, building efficient systems for each product type, and then being able to scale through team development. And this kind of comprehensive training, this is exactly what we teach and provide you in Catalyst. We don't just teach you how to write chronologies. We teach you how to provide the full range of work products attorneys actually need. And through specific and individualized feedback, you're going to learn how to create professional work products that attorneys value and are willing to pay a premium for. The ability to provide multiple types of work products, it doesn't just make you more valuable to attorneys, it multiplies your income potential and makes your business basically recession-proof. When you can only provide one service, you're limited by market demand for that specific product. But when you can offer comprehensive medical legal services, you become indispensable to attorney practices. Now, in Catalyst Coaching and Mentoring, we teach you how to create each of these work products at a professional level, when attorneys are going to need each of these analyses, how to price your services appropriately, how to position yourself as a comprehensive resource, how to market yourself to consistently gain new clients and grow your business, and how to scale by training team members in different specialties. We provide you with templates, examples, individualized feedback to help you master each of these critical skills. So if you're interested, check out our free training, learn more about this dynamic field and how we can help you break into it. The link's in the description below, and your comprehensive legal nurse consulting practice is right there. You just got to grab it. Guys, I appreciate you watching, and I hope to see you in the next video.